Good morning, everybody. Welcome to our WhatsApp privacy policy testing the South African data laws seminar. We are broadcasting today online from Nelson Mandela University. I just would like to thank the organizers of this event for organizing this important event. And also would like to welcome our guest speaker, Advocate Johannes Wiepen from the Information Regulator, who will be our guest speaker for the day, as well as the distinguished panel that we have here this morning. So without wasting further time, I just want to give you a short background about the speakers that we have here today. I will start with our guest speaker, Advocate Colin Whippond. Advocate Colin Whippond is one of the full-time members of the Information Regulator, and he is also, as said, advocate of the High Court. He has also worked for several public institutions as well as private institutions prior to joining the Information Regulator as a full-time member. Then we also have Advocate Francis Cronje. He's also no stranger to the ICT law, cyber law fraternity. He was the co-author and co-editor of the textbook Cyber Law at SA 1 and 2, which back in the days he co-wrote with Reinhard Bass. He's also a consultant on numerous aspects of data privacy and cyber law. Then I also would like to introduce to you Ms. Amor Burger-Schmidt. She's an attorney with Werksmans Attorneys in Johannesburg. She's also very much involved on the data protection scene in terms of awareness and advising clients on how to get compliant. I also wish to mention she's also an author of a textbook that I actually referred to from time to time. It is a commentary on the POPIA, which she has written together with Professor Burns. A very interesting book that I think one should really have if practicing in data protection. And last but not least, I would like to also mention Mr. Lucian Pierce. He's also no stranger to the ICT law fraternity, one of the first ICT law firms to be based in Johannesburg, a specialist on telecoms, cybersecurity, as well as other aspects relating to data protection. So for today, as mentioned, the topic of discussion will be the WhatsApp privacy policy, and whether our South African data protection laws, and I assume that I guess our constitution would also come into play, whether our laws can actually adequately protect data subjects from abuse by responsible parties. Maybe just for an introduction, in terms of data protection, you and I, the owners of the personal information, are data subject for all intents and purposes, and then the person who is processing the personal information of yours, that would be known as a responsible party. You may have heard the words data controller, and you may hear some of our presenters using those words interchangeably, data controller as well as responsible parties, as data controller comes from the GDPR, which we look at as international best practice. And then you may also hear about operators, and those are persons who are processing personal information for and on behalf of the responsible party. So what caused the uproar amongst the public was because WhatsApp had decided on its own accord to change its conditions of service, which obviously they would be entitled to in a perfect world. But now the issue is to what extent do they want to change the terms and conditions? and what type of information is it that they want to take from data subjects, and what type of information they want to share either amongst themselves within their group or with other organizations. Please, this is a platform for sharing of intellectual ideas and for discussing the legal effects thereof. We are not here to bash any social media company. We are here simply to look at the law and to discuss it on an academic level to see whether there is space for improvement or whether the conditions can be accepted as they are. So without further ado, I would like Advocate Wepond to come to the stage, or should I say our virtual stage. Advocate Wepond, are you there? Let's see. Advocate Wepond?
Good morning, Prof. Snail, and good morning to all the participants and attendees, as well as the other guest speakers. I'm not too sure if I'm visible.
Yes, you are.
Okay.
Yes, you are. It's your floor now.
Okay.
Thank you, Advocate.
Thank you, Prof. Prof, thank you so much. I think this session is quite helpful and useful in the sense that it will provide, to a certain extent, some type of continuous discussions on this platform and all other platforms that's tasked with discussing this matter. But just to get back to the regulator, basically, just look at the regulator and currently how the regulator is continuing to establish itself. The regulator has appointed an acting CEO after its CEO has resigned to actually ensure that the regulator continues with the establishment of its administration. That's very important because the administration of the regulator includes recruiting and staff, so that we can acquire the skills and the expertise to ensure that we regulate the processing of personal information effectively and efficiently. So that becomes quite critical, and the regulator will recruit and continues to recruit staff in line with its available budget. Okay. Concerning the members of the regulator has gained a new member, and that's now Ms. Tully. And we now see a full complement of members, and safe to say that the term of the current members will come to an end close to the end of the year, which is 30 November 2021. Now, the question around social media platforms and compliance with FOPIA, what is very important to note is that compliance by social media platforms with the provisions of FOPIA is non-negotiable. That's very important to note when it comes to compliance within the borders of the Republic of South Africa. And what is also very important is that a failure to comply with the provisions of FOPIA by social media companies will then carry material consequences, which includes a fine of up to 10 million rand or imprisonment of up to 10 years. And this is in line with Section 107 of FOPIA. And what is also very important to note is that the regulation specifically of FOPIA makes provision for responsible parties to design a compliance framework, and that will be after they have conducted what we would call a privacy impact assessment to assess the gaps within their systems. I know that when it comes to the GDPR, they refer to what we would call privacy by design, which means that when you design your systems, you make them POPIA compliant instead of privacy by default, where you have to fix a system. What is also very important for us, coming to the existing challenges with regards to social media platforms and regulating social media platforms in South Africa. I can just give you some synopsis, and that includes the following. The way in which social media, the social media companies are designed is that they do not have a fully fledged presence in South Africa. Instead, their presence is almost, and I want to be careful here, almost a type of a post box arrangement. And this means that there's no effective decision making, if I can call it, no effective decision making powers that exist when they do have a presence. And this emanates from a case study that the regulator has conducted or its engagement with Facebook with regards to the Cambridge Data Analytica breach, which of course saw a compromise of in excess of 400,000 South African citizens or users' personal information. And what then happened is that it became so difficult for the regulator in South Africa to engage with anyone in South Africa. Instead, we were referred to the island office, and that office was then tasked to engage and interact with us. But what also complicated the situation is that the regulator was also referred back to the UK, who was at the time conducting an investigation in this regard. So what we see is that the further away the decision makers are based, the more complicated regulating these social media platforms becomes. And this now forces me to introduce the point of information officers. Information officers, in terms of POPIA, there's no explicit requirement about where they should be based. But what is very important that we can see is the fact that DIOs, there's also no explicit requirement other than the fact that they must be employees of a specific company. Now the regulator don't know if, and we have not taken a view, if DIOs, Deputy Information Officers, will be appointed in the South African, based in the, or have a South African based presence as part of its more effective communication with some level of persons who are tasked with decision making responsibilities, so that we can achieve effective regulation of social media companies. What is also very important to understand is that there are two ways that the information officer can create what we would call an extension of his office. One is by authorizing an acting information officer, and that acting information officer is not required to reside within the company. And the second aspect is that the deputy information officer must then be the employees. And those options provide for an opportunity for the regulator to look at a more useful engagement with these social media companies. And another aspect that we need to understand is that the regulator, in order to regulate effectively and efficiently, must have greater cooperation with these social media companies. And by greater cooperation, I want to stress the point that there must be continuous direct engagement with decision makers instead of persons who will then take whatever the information regulator raises as a concern and forward it to other people. So it becomes very crucial for effective and efficient regulation to actually have direct access and direct continuous engagement with the decision makers of the social media companies. And what is also very important for us, if we look at the challenges, one of the key challenges, which I think was not, is actually if I can use the word undervalued, is the fact that there's a lot of storage and dissemination and processing of COVID-19 related personal information on these social media platforms. And I think that provides for an opportunity for us to also look at it because that provides, a lot of difficulty because we don't know the extent to which these social media companies have access to this personal information that gets to be disseminated on these platforms. And what is also very important to mention, coming to WhatsApp and the policy changes, the regulator noted the proposed changes that WhatsApp intends to introduce.
It looks like we've lost Advocate Weapon there for a second. Hopefully he will be able to join us again. It's a pity that the connection seems to be an issue, but yeah, it doesn't matter. I think then what we can do is until Advocate Weapon comes back, we will be able to ask him questions, or should I say the regulator in particular, once his technical issues have been resolved. So in order to move on right along, I think it would be nice to ask Advocate Francis Cronje to get on the floor. And like I said earlier on, if there's any questions that you have for the speaker, immediately after the speaker, we will have a short Q&A session for some direct questions. And then later on, we will have a panel discussion where you may be able to speak to all the speakers. I see Advocate Cronje has already got his presentation up on the screen. Advocate Cronje, are you there? Right, I see the slide is coming up. Advocate Cronje?
Yes, I just want to confirm I'm here, Sizwe, Professor Snail.
Okay, lovely. Over to you then.
Again, very nice and welcome to everybody. I suppose by now we're all pretty used to these webinars and stuff in this new reality that we live in. But it has its benefits as well, I suppose. So we'll try to be optimistic about the future. And I hope as we progress in doing these things, hopefully all our technical issues in the next year will be resolved. But it's always a constant worry is technology when one does these webinars. And at the same time, also I've seen it with a lot of my clients when you do these meetings. Some people disappear, some people forget on their screen, some people do, I don't know what. But it's a funny world, but here we are. So yes, welcome everybody.
Can you switch on your camera, please?
Yes, my camera is switched on.
Okay.
But I think it's probably not going to show while my presentation is up. But let's take it from here. So my approach to this whole issue, and thanks to Advocate Weapon for clarifying certain things, I'm sure we will ask him a lot of questions pertaining to what he has raised. But my sort of perspective is almost, and if everybody can see the next slide, is currently we're experiencing something in this, what we call the so-called fourth industrial revolution. And for me, there's strong comparisons to that and what happened during the second industrial revolution, which can be called the technical revolution, which was fueled by oil. And now we're in this situation where we have the digital revolution and it's fueled by data. And that brings with itself a lot of concerns. I see we have a little bit of a delay when we move from screen to screen. So let me just see. I just want to hear with the producer, can you see the next screen, or are we stuck here between similarities between the second industrial revolution and the fourth industrial revolution?
Yeah, we're still on that slide, Advocate.
I will start talking and then make sure that I follow up with the slides. It seems like there is a bit of a glitch. Okay, there we go. So one of the first things that I think there are pretty strong comparisons to be made is what we refer to as antitrust. That's an American sort of like terminology. In Europe, they utilize cartels, and here in South Africa, we talk about competitive measures, and hence the fact that we also have a competition commission. And what I want to do is draw the similarities between these two revolutions that we're currently dealing with. If you go back and you look back to how it was during the second revolution, obviously the main driver there, as I said, was oil. And interesting, I came upon this article that was published in the Wall Street, and what they did is they titled it "The Antitrust Case Against Facebook, Google and Amazon." So the article reported that these major tech firms each have greater control over certain high-tech industry sectors than Standard Oil had over oil production during its heyday. Now, for those of you that are still alive and remember the 1870s too, no, I'm just kidding. But what happened is with Standard Oil, obviously in the 1870s when they started with kerosene and they moved on, towards 1910, the American government thought these guys had too much control because from a competition sort of perspective, they didn't only have horizontal integration, they also started going to what we refer to as vertical integration. In other words, what the Rockefellers did is they bought the railway lines as well. So at the end of the day, it was almost impossible for anybody to compete with them because from a horizontal perspective, they made sure that they had all the facilities to manufacture equipment to produce oil or to drill for oil. And then from a vertical perspective, they made sure that they have like most of the transport system under their control. So for any competitor, it almost became impossible. And for users, they didn't really have a choice because Standard Oil was more effective. It was distributed across the country. So everybody almost started utilizing Standard Oil. I mean, even the Wright brothers, when they took to flight, they were guys ready with a Standard Oil, a little can. And the same when Ford started with its new innovations of mechanizing the production of vehicles, Standard Oil was the choice. But by 1910, 1911, the American government under the Sherman Act decided enough is enough, and they broke them up and they split them into like 34 companies. Now, an interesting thing that I read on the International Association of Privacy Professionals website is they speak about horizontal integration in the context of nascent competition or future competition concerns. And they say that this potentially exists where one of the merging entities has the capabilities that are likely to lead it to develop new products in the future that would capture substantial revenues from the other merging firm, and then where one of the merging firms has a strong incumbency position and the other merging firm threatens to disrupt marketing conditions with a new technology. So long story short, I don't want to go into too many details, but this horizontal merger guidelines come from the American Federal Commission in terms of guidelines and some of the guidelines that they utilize in antitrust cases. But some antitrust commentators have raised these concerns in their hindsight analysis of Facebook's acquisition of Instagram and WhatsApp. So if we do that sort of comparison, we can see that there is a bit of horizontal integration Now, I'll give you an example. 95% of young adults using the internet subscribe to a Facebook product, whether it's the company's flagship social net or other services like Instagram, WhatsApp. Google, on the other hand, control about 89% of internet searches. It's massive. If you now go and look at it, and one of the reasons I'm trying to make this comparison is to see what other alternatives are there for us. Obviously, we've got the information regulator, but what are the other alternatives that are available to one globally? If you go look at the traditional antitrust or anti-competitive analysis, they basically contain that competition laws are intended to protect competition and is not intended to protect consumer privacy, and that current antitrust laws are sufficient to address antitrust harm in digital markets. But now I want to ask, really, if you go look in 1910, when Standard Oil was broken up, and we take here inflation into consideration, they had something like, I think in today's money or 27's money, the equivalent of about a 938 million. And in today's money, that was deemed appropriate to split them up into 34 companies. If you look at the tech giants, and as Sizwe stated, we're not like shooting everybody down. I'm just here talking facts and reality. If you look at these guys, I mean, they are far exceeded the time when governments acted upon monopolies. So all of these in today's standard, I mean, is probably about 100 times worse than what Standard Oil was. So the sort of like confluence that we have today is there must be some sort of countervailing view. And they refer to it as, sometimes as what we refer to as hipster antitrust or the new Brandeis. It's not Brandeis, guys. I know we're in COVID lockdown, but it's the new Brandeis approach. Basically what this Louis Brandeis did in the 1930s is he stated that surely if we look at something from an anti-competitive market, you can't just look at price-based consumer welfare. You must extend it to other sort of things that are influencing it. And from a privacy perspective, we say that includes access to data by rivals as a constraint on monopoly power. And funny enough, a while ago in Europe, antitrust regulators tried to make that connection under an abuse of dominance theory. So the German Federal Cartel Office and Professor Snail, who is very good with his German, can probably give us the correct pronunciation, but it's the Bundeskartellamt. Prof, just alert me to the fact if that's not the correct translation. But they sued Facebook last year, alleging abuse of dominance, where Facebook's data policy permitted the company to collect and combine user data from non-Facebook websites without adequate user consent, and then to assign that data or that outside data to Facebook user accounts. Funny enough, on appeal, Facebook then basically overturned it. But I think what is important, and remember, this is some sort of a policy shift that I'm talking in terms of anti-competitive or antitrust laws. The higher regional court in Düsseldorf stated that the connection between data protection and competition that Federal Cartel Office sought to establish against Facebook, it was not rejected outright. In other words, they're leaving room for it. In other words, some of the FCO's sort of like approaches in taking this to court maybe didn't hit on the sweet spots, but there are other things that are. And what they basically stated, it's not excluded from the outset that damage to consumer protection may be regarded as a norm-relevant damage to competition within the meaning of German competition law. And funny enough, now after WhatsApp came, and they updated their privacy policy, or they gave people this notification that it's going to happen and you have to either accept it or toss it away before the 8th, we saw quite a big outspoken critic of it was President Erdogan from Turkey. But funny enough, in Turkey, they didn't go the data protection route. They also went the antitrust route. So with WhatsApp's recent update, you can see a Turkish antitrust authorities also announced they are investigating WhatsApp updated terms, objecting to what they claimed are differences in how much data will be shared with Facebook under the new terms in Europe and inside. So The reason why I'm bringing this up and once again drawing the similarities between this and oil companies, now in hindsight, when we look back at, like the monopoly oil companies have had over all the years, we can see what the subsequent results are. In other words, you see different standards for different economies, and I like to refer to it as different economies. I don't like the term third world. I don't think countries that have a lesser economy must be regarded as a third world. It's got a bad ring and taste to it. I just think we are emerging economies, and that's probably the term that is nowadays being utilized. But we see that once you're a monopoly or you control vast amounts of a specific sector, then you start to employ different standards for different economies. There's this interesting article in the Journal of Law, Policy and Globalization titled Oil Exploitation and Compliance with International Environmental Standards. And then there's this case of double standards in the Niger Delta of Nigeria. And what they stated there, they said for 5 decades. And the reason why I'm making mention of this as well, some of these things are sometimes left too late. And then the subsequent consequences is almost irreversible. But for 5 decades, environmental damage such as oil spills and gas flaring caused by the careless and reckless operating practices of the oil multinational corporations remains a permanent feature in the Niger Delta region. If you look at it, I mean, and that used to be pristine territory. I mean, it's unbelievable how it looks there. I mean, like there's still cases that are ongoing against Shell, for instance, and I'm not here referencing a specific oil company. I'm just talking of things that are still in the news. It's just, it's almost as if the will to clean up the things are not there. It's always linked to money. How much are we going to be fined? How much can we actually get away with, etc., etc. And it always seems to be the emerging economies that are suffering most. So the article goes further and it states that the activities of these oil corporations seriously destroy self-sustaining ecosystems, and they undermine people's ability to meet their basic needs, which include food, clothing, shelter, safe drinking water, health and clean environment, and above all, the quality of life in which they live. If you put a data hat onto this and you compare it with a consumer that at the end of the day is subject, for instance, to a data breach or to a data controller or responsible party, as we refer to them here in South Africa's abuse of their data, you're going to have like similar consequences in 5 to 10 years if we're not already having that. It can range from identity theft to a whole array of other things, and at the end of the day, it will influence people's real lives. But yeah, there's an example, it's like an aerial shot of how the Niger Delta does look. So there's complete abuse, and this is what's interesting to me in the article. It says little or no regard is paid by the oil multinational corporations to the laws regulating the oil industry in Nigeria. Now look at this little map, and it might be a little bit outdated, but I've got a couple of them. There are nearly 100 countries around the world that have adopted data protection and privacy laws. What does WhatsApp make a distinction of? That little area there, and the rest is almost like sort of ignored. It's like, and if you're not there, then this applies to you, whatever our policy is. They won't say, if you live in South Africa, read our privacy policy pertaining to POPIA or the AIPP in Australia, or the data protection laws in Uruguay or Argentina or Canada or wherever they are in the world. There's no distinction being made. If you go look at the United Nations, they stated that 66% of countries have data protection legislation, while 10% have draft legislation. Once again, and I mean there are a lot of countries, so 66% is probably now more than the 100 that I referred to earlier. But once again, I mean, here you can see, here are comprehensive laws in these countries. You've got sectoral privacy laws, like in the States, for instance, in Alaska, then Morocco. And then you have like what we refer to as partial privacy laws. But you can see it's pretty much covered to a large extent. But once again, when WhatsApp differentiate between their privacy policies, and that's, I suppose for me, that is what I've got like a little bit of a problem with. They seem to focus just on this little area. The next slide, that's just how it applies further on in terms of both public and private sector. But we can see there are a lot of privacy laws across the world. And now you go and look at where WhatsApp is utilized in the world. Pretty much here in Africa, South America, India. In India, there are more than 500 million users of WhatsApp. If you go look at Europe, yes, there's in the UK a bit, in Ireland there. We can see in France not so much because they utilize other sort of tools. Funny enough, they use Facebook Messenger, and the same is in the States. But there's a lot of countries that are utilizing WhatsApp. In Spain, I know about 88% of the people utilize it there as well. But if I go back one slide there, and you look at privacy laws, and then you go look at application. I mean, Brazil is the second biggest user of WhatsApp. I think they're on about 300 million. And in total, I think 2.5 billion people. So about 50% of the users are split between India and Brazil, probably about 40 or 45%. Now, my question is, you go to their WhatsApp privacy policy, to the update, and this is what it says. If you live in the European region, WhatsApp Ireland Limited provides a service to you under these terms. So earlier this month, Ireland's Data Protection Commission, and it's funny that Advocate Weapon make mention of the fact that they tried to work with them. They said, and obviously they are the lead data regulator in the EU of WhatsApp because of the data centers being in Ireland or Dublin. They stated that the messaging app has given it a commitment that EU users are not affected by any broader change to data sharing practices. So Facebook's lead regulator in the EU, he hasn't raised any objections to the new WhatsApp terms and conditions. And once again, for me, this is very weird. It almost reminds me of the way that vaccines are distributed nowadays. But it seems to be a preference when it comes to EU users. Yes, they do have very strong legislation, and yes, the fines are massive. I mean, we know what the fines are. So if I compare to South African fines, it's actually laughable. So my question then is, why does WhatsApp differentiate? Is it because they really care about privacy, or is it because they just scared of those countries that enforce it with heavy fines? So I go back. If you go and look our Facebook, work with other Facebook companies in the EU, this is their terms and conditions. And funny enough, look at that. Any information WhatsApp shares on the basis cannot be used for the Facebook company's own purposes. In other words, they utilize Facebook as a processor / operator. They don't share it with them being a data controller. And that obviously have like a lot of benefits if you are a user, because you afforded more protection. If you go look at what Elizabeth Denham, she's the Information Commissioner in the UK, she said that the new changes won't apply to UK users under a 27 deal her office reached with WhatsApp. The company agreed not to share user information and contact details until it showed it could comply with the European Union's general data protection legislation. And this was the letter that she drafted. And funny enough, this is exactly what is happening now. It was after WhatsApp in 2016, end of 2016, beginning 2017, they decided they're going to update it, and they followed exactly the same methodology as now. Now you come to, if you don't live in the European Union, and how do we then work with other Facebook companies? There you go. Nothing about them not allowing Facebook to utilize it for its own purpose. So this is completely different from what they apply under GDPR. So bring me then back here to this point. WhatsApp is updating its terms and privacy policy. So they say by tapping agree, you accept the new terms. In other words, they infer that you consent. After this date, you will need to accept these items to continue using WhatsApp. The question then is, what consent? What consent are we talking about here? Because the definition of consent is something that is freely given. It's specific and an informed expression of will. First, I think from an informed perspective, they don't meet the obligation because the privacy notice is not detailed enough. They would, for instance, refer to other third parties. We might share it. We might update this and we might do that. There's a lot of legalese in those things if you go into the details. The other problem then is, obviously, if you have market domination and you have such large percentages of people utilizing your app, that guy doesn't really have an option. He has to keep on using that app. So is his consent ever freely given? I doubt it. It's more out of necessity because there's not enough competition. There's not enough other apps that one can utilize. Obviously, there's been a drive, and we saw that how people switched over to other networks like Telegram and Signal exactly because of this. But it's quite interesting if somebody has market monopoly, how things can change. And I think in this fourth industrial revolution where we are, where data is the new oil, I think antitrust laws and anti-competitive laws need to start incorporating what we refer to not as the brandy approach, but the Brandeis approach. In other words, that you look at other things and not just like the price competitive aspects, because data in itself is becoming the new commodity. So I think, long story short, you're going to see in the future probably your competition commissions, and I'm talking here only about the big tech giants, but your competition commissions and your regulatory authorities that are dealing with data protection would probably from henceforth start to work together, because I think it's the only way that you can resolve it. From a South African stance, I don't think our fines are enough. You can't send people to prison for what they do, because that's only if you don't comply with certain enforcement notices or you try and influence the regulator. It's going to be very difficult to do that. And this is peanuts for Facebook. If Facebook or WhatsApp or any of the big giants, if they can, through their types of advertising or their abuse of data, generate billions, what is 10 million rand going to be at the end of the day? So these are just a couple of things that I wanted to bring to your attention. It's, once again, we just want to make clear we're not bashing anybody. We're throwing out ideas here. And I thought this was just putting a little bit of a different angle on it so that one can see what the relations are and what can we learn from history. Are we going to wait another 10, 15, 50 years before we actually start doing anything about it, or is it going to be too late? So yes, thanks. And that's me in a nutshell.
Thank you very much, Advocate Cronje. I think a very interesting discussion, not just focusing on data protection, but just showing the shift from how things were valuable 50 and 100 years ago, and how data has now become the real currency that we use in this era of technology. I just want to ask if there's any questions from the floor at this stage for Advocate Cronje. If there are any, I would like to see them on the Q&A. Let us see. All right, for now, we don't have any questions for now, but maybe I have a question for Advocate Cronje. Advocate Cronje, the question that I have to you is, do you think that the POPIA is in line with international best practice, and do you think that the POPIA maybe need a rewrite, considering the fact that, you know, in the international data protection space, there's a lot of impetus, there's a lot of movement going on. I mean, a couple of years ago, it was the EU directive, now it's the GDPR, now I hear they are busy drafting again. What does that say for the POPIA? Advocate Cronje?
Yeah, thanks, Sizwe. And I think you're 100% correct. You know, you can remember the days when we had the Electronic Communication and Transaction Act and how long it took to enforce certain of the things. For instance, up until today, we don't have cyber inspectors. And the problem that you have with technology, it is constantly evolving. And due to the fact that it constantly evolves, it's almost like we always have to play catch up with legislation. I suppose, you know, when we were part of the drafting of POPIA, we sort of waited a bit until 2012 so that we could have the GDPR draft, so that by the time when it was enacted in 2013, that we're not in a position again where we are falling behind. But as you have seen, I mean, with the setup of the regulator, a lot of things have happened, and it has taken time. And there are constraints normally if you set up new offices, you know, like whether it be from a national treasury sort of perspective or budgetary concerns, it's always constantly evolving. And by the time that we're now in a position where we can enforce it, you're 100% correct, are we now maybe not like a little bit lagging behind again? And exactly the examples that you've used, like for instance, the EU bringing in a sort of like amended cookie directive now on top of like the existing data protection legislation, the way that the various countries in EU apply GDPR into their own data protection pieces of legislation. You know, like for instance, when labor laws in South Africa change, you know, doesn't it mean certain things in terms of POPIA must change as well? And I think there are certain concepts where we are lagging behind. I think there's maybe a possibility that that can be resolved in regulations, because a lot of room has been made for the regulator to issue regulations for those areas where I think technology is going to evolve and maybe we stay behind. Also, in terms of the fines, you know, the question is always going to be what teeth do we as regulators have? And I think that's always going to be a constant debate, because in the EU they've made a very good example of what should happen. And the reason why I referred here to anti-competitive behavior, we know that Competition Commission in South Africa utilize also turnover. And I think turnover as a fine is something probably that will need to be changed going forward, because I think that's the only way that you could be successful in showcasing. Because if a large technology company loses 4% of their annual turnover, then it will hurt them. But if you say you've got like a static fine of 10 million rand over a period of 5 years, it's not going to really send a message.
Thank you, Advocate. We now have some questions here from the audience. The first question is from Gary Richards, and he says the issue of consent is no different from many other sectors. If you apply for a mortgage bond, you don't really consent in the sense that you have no power to negotiate. You want to comment about that?
Yeah, I think for me the trouble is, yes, you know, if there were only one bank, that could have been a little bit different, correct? But now you're sitting in a position where you've got plenty of banks, so you do have like real choice. For me, in terms of like the social media and the domination by certain role players, makes it a little bit difficult. And it also depends on the various technological platforms that are there. Sometimes they come on board, sometimes they don't. If you're an existing user and you've got like 150 people that you are communicating to on a specific platform, and now suddenly, if you don't consent and in inverted commas to our privacy policy, you're welcome to go. You know, like there are practical sort of things, and then people start to weigh up, is my privacy really that important? You know, this constitutional right that I have, does it really weigh up because I've got all these friends that I want to talk to? Then that sort of like freely given aspect completely go down the toilet. And I'm sorry to say, but there's a reason why consent is split up into 4 categories, meaning freely given, specific, and an informed expression of will. I don't see the freely given there. Under GDPR, they even took it further and they said unambiguous freely given. So from that sort of perspective, I'm not 100% in agreement. But to a certain extent, if I'm a new user, yes, maybe, you know, then you have a different sort of criteria in terms of consent because you haven't used it as of yet. But if you're an existing user, it's almost like with employees where you have a new privacy policy at work, then you need a different approach. You can't just say, listen, we're changing it. And funny enough, one of the things, that letter from Elizabeth Denham, it's quite valuable maybe for you guys to go have a look at it, because in that letter, she raises precisely these issues. That Facebook at that stage, when they wanted to update their privacy policy, or sorry, WhatsApp, when they wanted to update the privacy policy, it was exactly the same contention, because now it's suddenly utilized for a different purpose. You need to obtain my consent, but if you contain my consent, it has to be freely given. So that's the long and short to that question.
Thank you, Advocate Cronje. We have 3 more questions here before we go over to our next speaker. I also noted that Advocate Whippand is back. His technical glitch has been sorted. The first comment here is from Zuko. Zuko says, mine is not necessarily a question, but just a comment, basically from Advocate Cronje. With our South African fines and penalties, companies can easily budget for non-compliance. So that is Zuko's comment. And then I see here a question from Nathan Ross Adams, one of our colleagues from the legal fraternity. Advocate Cronje, what's your view on the Facebook WhatsApp approach to competition when it comes to government chat? Maybe you can give us your views on that, and then I'll come to the last two questions.
Sorry, Sizwe, can you just repeat the last bit when it comes to what chat?
Oh, okay. The question is, Advocate Cronje, what's your view on the Facebook WhatsApp approach to competition when it comes to government chat? In other words, this ongoing case that's in the competition tribunal from government chat against WhatsApp. I think that's what he's referring to.
Yeah, so sorry, man, my background on that is not 100%, so I don't know if I'm in a position to actually comment on that. Maybe Sizwe, if you're aware of that case and what I inferred in my presentation, maybe you can answer that.
Right. I think in a nutshell, I think government chat is basically saying that WhatsApp / Facebook are conducting themselves in uncompetitive practices. And therefore, they've now gotten a temporary injunction until the court actually decides on that matter. But I think maybe one of our other speakers will also comment about that. And then the last two questions for you, I'm just looking at the time, I want to manage it properly. It comes from Will A. He says, Advocate Cronje, do you think there will be more and more of a need for cyber lawyers the way things are going? And the last question, I just want you to note it, from Anonymous, how do we balance the need to regulate and a person's right to freedom of expression? Thank you.
Yeah, thank you for that, and I'll stop with the cyber lawyers. I will address that. I think the first one is an interesting debate in terms of freedom of expression. You know, we saw what happened in the United States, and now Twitter is starting to regulate people's access. Now, irrespective of what side of the aisle you are, whether you're apolitical, whether you're this side or that side, that's not the issue for me here, personally. I feel the whole idea why the internet was formed was to provide people with that right of freedom of expression. And it's a very... Obviously, the right doesn't come without restrictions, but the question is, who are the adjudicators of what my right or my freedom of expression is? And I feel if you leave it to technology companies to make decisions, then you can end up in a very, very dark place. So for me, there need to be independent bodies that actually make those decisions. Obviously, you have different sort of like communication platforms out there. Some are large, some have their own sort of way of making rules. And yes, they do have that right. But I think at some stage that what is in the public interest, what is not in the public interest, those sort of like decisions need to be made by regulatory authorities. I just think we're playing a very dangerous game if we allow big bosses of tech to start making constitutional decisions. Then coming back to the first question of the cyber lawyers, yes, I think, you know, when we started, and Sizwe can tell you right in the beginning, people sort of like laughed at people when they spoke about IT law. They thought it was like some sort of, yeah, I don't know. They just thought people were a bit silly that there's something like IT law.
Used to call us PlayStation lawyers.
Yeah. So from one PlayStation lawyer to another one, I would say that I think it is a field that is going to develop rapidly, and I think what is nice, Sizwe, especially now being a professor there at the Nelson Mandela University, it's nice to see that people that have had experience in the industry itself, that they are also now in positions to teach other people and bringing new students into this foray. It's a very interesting field of law. And at the end of the day, you know, it spans across the whole business, and there's so many things to take into consideration. I think it's an exciting field as we speak of the so-called fourth industrial revolution. I think a lot of things are still going to happen in this space. And for those young people that are maybe listening and that are students and trying to distinguish what subject they have to take in law, I think it's a very interesting subject going forward. But yes, the role is going to drastically change. I think one of the things that we saw with COVID is that people suddenly started becoming aware of their privacy. The moment government said that they're going to have an app tracking people, people suddenly started becoming aware of their privacy. And I think from that sort of perspective, this is going to create a whole new job economy in South Africa. The digital sort of like realities that we have, from cloud to the people regulating it to lawyers giving advice on it. But it's interesting times lying ahead of us. So yes, definitely cyber lawyers will become really prevalent in this industry.
Thank you very much, Advocate Cronje, for such an insightful presentation, as well as showing us the developments of data protection and where we are. Like we said, from one cyber lawyer to the next. Thank you very much for that. We've managed to get Advocate Weapon back online. We'd just like him to finish his presentation before we go on to the next speaker. Advocate Weapon, are you back now? Let's see. Are we winning there? All right.
To get video on. I'm back. Thank you, and apologies for that.
Okay.
Issue to deal with.
All right. Can you switch on your camera for us, please? Then over back to you, Advocate Weapon.
Thank you, Prof. I'm not too sure if my camera is actually picking me up.
Yes, it is now.
Okay. Prof, thank you so much. The issue that I touched on before I got cut actually relates to the fact that the information regulator has to date started with a process to analyze the policy of the privacy policy of WhatsApp, and that will be, Prof, for the people or the users living in Europe and the users living outside of Europe. So there are two policies that the regulator is currently analyzing. And what the regulator is also doing is to then take a proactive approach with regards to the terms of service and the privacy policy for users living outside of Europe, particularly looking at that new policy and its compliance with the provisions of FOPIA. And currently, Prof, you have been tasked and myself to look at analysis, and we are currently finalizing those analysis. But what is also of concern, Prof, and the participants, as well as the speakers, is the fact that we have now entered what we would call an era where the regulators need to dedicate a lot of resources to regulate social media companies. I'm also now referring to the UK's latest announcement that they have an intention to write to Facebook with regards to the sharing of data between the family of companies within Facebook. And that is one of the issues which we have picked up in the new policy, which also raises a concern with regards to the issue that Advocate Cronje referred to about consent. And it also raises an issue with regards to further processing. And those issues, I believe, will also come out clear in our analysis. And we also intend then to engage with Facebook in this regard as soon as our analysis is complete and approved. And then, Prof, the last point that I wanted to make is the fact that we had a visit a long time ago from Ms. Atkinson, Carol Atkinson, the Vice President of Google, and she has pleaded with us when we're still 1 year in office to actually not stifle innovation with very rigid regulations. But we then undertook and discussed with her to say that the regulator's approach is non-negotiable, but we will also try to strike a balance between innovation and regulation. I'm going to stop there, Prof, and thank you so much for the opportunity.
Thank you very much, Advocate Wiepend, from the Information Regulator. I'm not sure if there are any questions for the Office of the Information Regulator that you would like to ask. I'll have a look at the Q&A platform. Maybe one question from myself. If WhatsApp is found to be conducting itself, not in line with POPIA, what is the regulator most likely going to do, considering that we are still in the grace period? What type of action would the Office of the Regulator take under the instances? Because that is something that the public really wants to know in light of this grace period. Should we comply? Should we not comply? Maybe if we can have that question from the regulator answered. Advocate Wiepend?
Thank you, Prof. What I think is important to appreciate is the fact that, and I think we need to appreciate the fact that the regulator is in a position to provide advice to a certain extent, and also and that in terms of Section 41. But what is also very clear is that we have adopted a process of support and guidance in the general approach or nature of our approach. But what is concerning is the fact that come the 1st of July, despite the fact that there is a discretion on the part of the regulator to consider a second grace period of 1 year, I think it was made clear at various meetings, Prof, where you attended as well and led discussions, that the regulator will not be making use of a second grace period. Instead, it will now activate its compliance and enforcement mechanisms. Thank you, Prof.
Thank you very much, Advocate. If there are any further questions for Advocate Wiepend, you are more than free to send some questions to the regulator, as well as on this platform for the panel discussion later. All right, thank you very much about that. We can now move on in the program, and our next speaker to speak is Amor Burger-Schmidt. As you can see there on the screen, she is a director and the head of data privacy at Waxmans Attorneys in Johannesburg. She's a renowned attorney. She's really a expert in the field pertaining to data protection. I've also mentioned to you earlier on that she's not just a practicing attorney, but she's also an author of a leading textbook dealing with data protection. So I don't want to waste a lot of time. We're already short of space. I would like to hand over to Ms. Burger-Schmidt to kindly take us forward. Ms. Schmidt, are you there? We see your slides, but we can't hear you. Yeah, I think yes, now your microphone is on. All right, thank you.
Right. Sorry about that. Thank you very much for the opportunity. It's great to address these topics because it is so very much important for us to analyze it and to understand what we actually confronted with. And therefore, I thought yesterday evening late, maybe the correct title for my little 15-minute discussion is Legal Principle in Fact, Not Emotion, because I do believe there are a lot of emotions in this debate and discussion from a data subject perspective. And I would like to shed a bit more light on it from a theoretical perspective. Just the question about GovChat and the competition law, competition commission process. We need to remind ourselves that GovChat is deemed as a juristic person, is deemed currently by WhatsApp to contravene the business terms. And what we've seen since the inception of the competition regulators is that a number of contractual disputes actually end up before the competition authorities and in urgent relief applications as well. So yet again, we've got a dispute where WhatsApp is saying, but this is a contractual dispute and it's got nothing to do about competition, but we'll see where that process ends up. Back to today's discussion where we talk about the first of all facts. So if we analyze the current announcement, I'm not talking about what happened over a period of time, update of privacy policies. The changes currently announced from WhatsApp in relation to their privacy policy, if you analyze that, not a lot have changed. In fact, what they clearly provide for and what they clearly aim to address relates to businesses. And someone asked the question about GovChat. It's not a warm body. It's not a natural person. Businesses utilizing WhatsApp for service, interaction with their customers, trading with their customers, and that link with Facebook. And we also know a lot of businesses do have their business pages on Facebook. So in a sense, we're between a rock and a hard place. So how do we marry all of this in the era where we live and where online commerce are increasing by the day? The reality is that if we consider the type of information that we are talking about and the personal information, yes, it relates to phone numbers and the details of users, and where the big debacle comes into play is the fact that not only will a data subject that interact in the channel, his or her or its contact details be captured, but in fact, behind the scenes, all the individual's contacts, all the individuals that he or she or it interacts with, that information, if they are on Facebook or on WhatsApp, will be pulled into the bucket of contact information, personal information, and that will be shared with Facebook. And it will be shared with Facebook for the purpose of, amongst others, targeted advertising. So yes, they've added a new feature. They want to get all this information into the one Facebook family bucket, to slice it, to dice it, to use artificial intelligence and to enable targeted advertising. By the way, when these mergers of Facebook buying WhatsApp and buying Instagram, when those were dealt with from an antitrust competition law perspective, the relevant market that the competition authorities looked at and analyzed it on was the market for advertising. So one has to ask yourself, if in this regulatory environment, that the antitrust authorities actually missed something, and now today it's become a data privacy concern. Another fact that I want to raise, and I'll quickly raise the next three, the WhatsApp chats are encrypted. They are end-to-end encrypted. That is very important. So all these jokes and animation messages going around that who's reading your chats, those are actually not true, because the poor WhatsApp that do offer end-to-end encryption, which is important for us as from a privacy perspective. If we consider Signal and Telegram, and we've seen the massive move to Telegram and to Signal over the past month, the Telegram chats are not encrypted. Even the secret chats, that key that Francis referred to earlier on, Telegram sits with the key On the WhatsApp side, no one has got that key. You've got the key. I've got the key. We as part of a chat. But in the Telegram instance, in the secret chat functionality, Telegram sits with a key. So I send a secret message, Telegram unlocks it, locks it again and sends it on to you. They sit with the key. And I think, we need to unpack these things. We need to mature as a society and actually understand a bit more what is underlying as certain aspects and these social platforms. Another fact is that this must have been, or is currently, the biggest PR nightmare imaginable, because we can't but say it was poorly executed. The communication to us as data subjects really lacked, and therefore this massive confusion. If we look at this whole debacle from a data privacy perspective and from the perspective of POPIA, I want to highlight two issues for the short discussion. POPIA provides for the 8 conditions of lawful processing, and in my view, 2 of these are very much relevant for the discussion today. Number 1, openness, because that links directly back to the terms and conditions and the privacy policy. And I'm going to ignore the European privacy policy. We're talking about the privacy policy that applies to us in South Africa. So the principle, the condition of openness. And then the principle of processing limitation, because I think that is important. And that processing limitation brings us to what are the lawful bases for processing. And one of these lawful bases is, in fact, legitimate interest. The legitimate interest of you and I as data subjects, but then the legitimate interest of organizations such as Facebook and WhatsApp. And I think it is important that we unpack these issues, because if we look at POPIA, we can't question or doubt the fact that the legislation in itself has been heavily influenced by international and foreign data privacy laws. It's clear if we read the legislation. The legislation itself says to us in Section 3 of the Act that we need to interpret this Act, the POPIA legislation, in a way that we harmonize it and the application of it with international standards. And then we can't read any piece of legislation in South African isolation, and we can't read it without reflecting on the Constitution. And if we look at the Constitution in South Africa, and I'm referring you to Section 39 of the Constitution clearly instructs us that, or instruct our courts, that they must give effect to the Bill of Rights in interpreting POPIA, and in doing so, they must consider international law and they may consider foreign law. So if we say this piece of legislation was heavily influenced and impacted on by international law, surely we need to take into consideration the GDPR and the EU legislation. So the question is then, this aim of WhatsApp to feed information into a Facebook bucket, where Facebook will be able to analyze it and target marketing, can that be justified? And can it be justified then on the ground of a legitimate interest as a basis for lawful processing? If we consider what the South African Law Reform Commission said, and they explained the approach when they, in their discussion documents, if we consider the lawful basis of processing and legitimate interest specifically, and consent that we just discussed in the previous presentation, the South African Law Reform Commission, and I'm going to quote, said in their 2009 report, a consent requirement is included as one of the lawful ways in which personal information may be processed. The legislation is, however, not consent driven. This means that there are other alternatives available. So as data subjects in the South African society, there's no right or absolute right that you have to consent to everything that's been done with your all processing activities in relation to your information. There are actually lawful interests and legitimate interests of businesses out there to process information. In fact, the South African Law Reform Commission went further, and specifically, if we consider legitimate interest justification, indicated that it may indeed be advanced to protect interest, and then we need to consider whether the processing is necessary for the purposes of the legitimate interest. And that brings me to the fact that if we consider legitimate interest, we know the legitimate interest concept has been delved and discussed and delved through and dealt with in a number of cases before the European Court of Justice. And we need to look at what those courts have said and what they've ruled, and understand also the opinions by the Working Party 29 in their discussions around how to deal with something like legitimate interest. And in fact, there are opinions by the Working Party 29 dealing specifically with legitimate interest. So considering the GDPR that specifically provides that a group of companies can rely on legitimate interest for the processing of information, we know that Article 7 of the directive lays down 3 conditions so that the processing of personal information is lawful, and in the first instance the pursuit of a legitimate interest of a data subject, but then also the need to process that information, the legitimate interest of the company in itself. And that is important that we consider this in critically looking at what WhatsApp and Facebook are currently trying to achieve and where they are heading. The European Court of Justice explains to us that, if we look at legitimate interest, and there are cases that we can reference, and if we look at consent-based conditions of lawful processing, to a large extent, these are case-by-case analysis and reviews that we need to take into consideration. So there's no one-size-fits-all, and we need to lift ourselves, understand the environment, and understand the law to actually apply that and understand that. So, on the same note, and then again back to the Working Party, and we need to understand that in Europe there's an expansive understanding of legitimate interest. And the Working Party 29 in their legitimate interest opinion clearly indicates that legitimate interest is a valid ground, and they say, and I quote again, for example, apply to the economic interest of a company to learn as much as possible about its potential customers so that it can better target advertisement about its products and services. So what Facebook is doing, WhatsApp and Facebook is doing, and the rest of the world, I would think they actually took a page out of the Working Party's interpretation of legitimate interest to say, but there is a legitimate interest for us to understand our customer base, existing and potential, better. And that's the question against, and the backdrop against which we need to apply POPIA and understand POPIA. So the question is whether new technology or processing, a new way of processing data or personal information in a new way, that a data subject could not have anticipated, if that meets the test from a POPIA perspective. And I think therein it brings us straight back to the concept of openness. Could the data subjects have expected or anticipated that their data will be processed in a specific way? So in a sense, what we are seeing, WhatsApp approached the data subjects in the interest of openness to tell them how their data will be processed, and the assumption is they believe on the basis of legitimate interest. While the data subjects in South Africa have turned around and said, but you never asked for our consent, and therein lies a massive disconnect in society. Also now, and I think this is very, very important for us in the South African society and the legal fraternity to understand, again reflecting on Europe and the application of the GDPR in Europe, it is an accepted principle in terms of the GDPR. The GDPR defines group of undertakings, and in fact, they define controlling undertakings and who controls the undertakings, and then make the statement that that controllers that are part of a group of undertakings or institutions that affiliate to a central body, current situation, example, Facebook, may have a legitimate interest in transmitting personal information within the group of undertakings for internal administrative purposes. And in terms of the GDPR Working Party, they specifically then state, including the processing of clients' or employers' personal information. So the point I want to present for us to think about and debate and explore is, we are and I've listened to various presentations in forums where people have been exceptionally critical about WhatsApp and Facebook and the changes that they're implementing. And I would think if we want to be critical, we need to develop the ability to actually evaluate the current situation on more than one level and not only on one basis or one condition for processing of personal information as set out in POPIA, which leaves, in my view, the current scenario with two questions. The fact that personal information are stored centrally and that Facebook and WhatsApp wishes to store that centrally and analyze it and utilize it to a certain extent, that is the question on the one side, whether that is problematic from a data privacy perspective. And I would like to suggest, if we reflect on the GDPR, that is in fact a legitimate interest basis for processing of the information. But then the other question is, so how will they be using this information? For what purposes will they be utilizing the information? And therein lies the conundrum, because what was the reasonable expectation of the data subject for this information to be used when you disclosed it on WhatsApp, and whether you had an expectation for that information to be further processed. And I think, the Information Regulator's Office mentioned the issue of further processing, because further processing is a very narrow provision in terms of POPIA. And we wait to be seen how the courts, how the Information Regulator and the courts in South Africa will then apply the concept of further processing. Because it's one thing to transfer the information into a central repository, but what you then do with that information must surely be linked directly to the reasonable expectation of the data subject. So yes, and hopefully all of us today have in fact watched The Social Dilemma on Showmax, and were shocked to understand in a certain way how artificial intelligence can move us to behave in a certain way. And we all watch CNN, and on the back of the elections in the United States, very much aware that things can potentially be then manipulated, and it creates a very emotive issue. And we need to ask ourselves, so why are the data subjects only getting upset now? Is it ignorance? Why have they taken so long? These privacy terms have been out there for data subjects, individuals, for a very long time. And why are they only getting upset now? And I think it is important to ask this question, because just the other day, the 15th of January this year, 2021, the bigger issue currently relates to WhatsApp that it's being used on desktops, PCs, because you can download the app onto your PC. And what was discovered through investigation in India, in fact, is that over 400 million users in India and professionals that uses the instant chat app on their desktops, that information fed back to Facebook and was shared with Facebook. And that is actually a far greater risk that no one has ever even spoken about. And allegedly, if we look at the desktop application, it exposed personal mobile numbers versus, and in terms of indexing it on the Google search engine, which actually exposes the information. So I would like to think, we need to educate ourselves. We need to educate ourselves in terms of the legislation, the principles underlying it, international law and jurisprudence informing it. We need to educate ourselves, and we need to educate data subjects out there. So, yes, Mark Zuckerberg is not listening in on our WhatsApp chats. It is encrypted. But let there be no doubt that we need to be serious about how do we protect as data subjects our rights, but at the same time, companies out there do have rights in terms of processing personal information. It's how they do that within the confines of the data privacy legislation. I think those are the thoughts that I wanted to share with you this morning to get the debate and the thinking going about what are we confronted with as a South African society. Thank you, Professor Snow.
Thank you very, 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 very much, Amor, for a brilliant presentation. It's always a pleasure listening to you. You've presented at numerous events of the Information Regulator, and I always just like the in-depth manner in which you explain things, but however also the way in which you simplify and make them digestible to the average listener. So I thank you for that. There's some questions here for you, Amor, if you don't mind. The first one is from Ellen Erasmus Morton. She says, if one remains on WhatsApp after the date of implementation of the new policies and one is not on Facebook, what are the actual consequences to the privacy of the individual?
Well, the reality is it's got nothing to do whether I'm on Facebook and whether I'm on WhatsApp. The fact is, if I'm only on WhatsApp, which Ellen, I'm on WhatsApp and I've never had a Facebook account. But if I remain on WhatsApp, currently just as a data subject, nothing changes in terms of the new privacy policy for me as a natural person. However, if I engage with a business on the WhatsApp platform, then I actually open up my address book and my contact list, and that information can then flow through to the Facebook repository, data hub, where they gather the information. Now, an interesting concept that I thought, with your phone pinging, I've always had a Telegram account as well. And, over the past couple of weeks, your phone keeps on pinging to tell you which of your contacts have joined Telegram. But the interesting concept for me in that is, so people exit WhatsApp, but they don't exit Facebook or Instagram. And that information, they're all in the same group of companies. All that information can be collated up into the Facebook repository. So it's very interesting, and I think that's part of it. Why I say it, I think it is the duty is on us to educate, the society around us, to know what is privacy and how do you protect it, and where do you actually, with whom you actually share your personal information.
Thank you very much for that answer. The next question comes here from Nathan Ross Adams. He's asking the following question. What about the principle of data minimization? The scope of the general privacy policy is extensive. Further, how can we consent to a policy where we don't know the details of how our data will be used by the Facebook ecosystem? Not even Facebook knows the inferences they can draw about our data when they use artificial intelligence when profiling us. Wow, that's a very explosive question.
Nathan, that is a stunning question. It's absolutely a brilliant question, and that is, it informs everything that's happening around compliance in the South African business community at the moment. Because yes, indeed, data minimization is crucial. That's exactly why we've got the provisions in terms of how long will we retain the information? How do we delete the information? That you shouldn't hold on to the information longer than you required, and that you only ask for what you actually need. it's crucial. And again, you're right, if the information regulator now analyzes the policy, and I haven't spoken about that because I didn't deem it appropriate for the current discussion in terms of my 15-minute slot, but that is an aspect in terms of the policy that ought to be investigated, the extent of the information. In addition to that, this consent to a policy that you issue, that you raise, as it is vital for us to understand, if we present a policy, the data subject is supposed to clearly understand who we're talking about, what we are going to do, where it's going to go. And I see too many policies where people adopt a copy and paste exercise in formulating policies and implementing policies and rolling it out, where they've got these broad brush strokes. And they've got the broad brush strokes because they haven't stopped and they haven't conducted an impact assessment. Like if you read the guideline in terms of the information officer that the information regulator issued, do an impact assessment, understand what you're actually doing, when, what, where, and how. And on the basis of that, you can actually formulate a proper, detailed policy, privacy policy or notice, where you rely on consent for the data subject to clearly understand who are we talking about. It's not third parties that might be relevant in future. What am I consenting to? Nothing. I can't consent to that because I've got no idea what it actually means. So Nathan, absolutely brilliant question.
Then we have two more questions. If you don't mind, Amor, I'm going to ask you both of them in one go. The first question comes from Professor Franz Marx. He's asking, can the regulator or any data subject effectively enforce our South African privacy rights against Facebook or WhatsApp in South Africa or in another country, given the jurisdictional and private international law constraints? That's a very nice one. And the second one comes from Mr. Gumede. Thank you for all the insight, Ms. Berger-Schmidt. Singling out the two conditions of openness and further processing was apt. So this is more of a comment, or no, it's a question. Don't you feel that education is ongoing and that it is actually the media pointing out WhatsApp updates that actually brought about the concern? So those are the two questions, or in fact, the last two questions. Thank you.
Can I start with the last question about the media? I think the role of the media in educating society is vital, and how we could, what we write and what we say in terms of the media, that is the way where consumers nowadays actually, where they go to understand concepts and the impact and the implications for them as individuals. So the media is very important. Whether it's only the media that raised this, I think the media's coverage gave a lot of impetus to the debate, but the reality is when everyone received that confusing message that the privacy terms will be updated and you won't be using WhatsApp anymore if you don't accept it, I think individuals themselves and as society raised the issues in conversations and debate, and the media picked up on it. And that's why I say the whole debate was driven by the fear, in the one sense, that people will lose the ability to use a platform that they very much used to, and the annoyance in terms of that. And then also we have over the last couple of years created more and more awareness to this beautiful, beautiful right in our constitution, the right of privacy, which has been ignored for far too long in South Africa. That's my comment on in terms of the last question. Then Professor Marx, indeed, this is a major issue. If we look at, the extraterritorial application and whether we need to give consideration to that and to what extent. I would like to pull the debate back to what we've seen before the competition authorities in relation to the Forex bank prosecutions, where the Competition Tribunal and Competition Appeal Court dealt in a very detailed way and manner with the concepts of how our legislation applies to a peregrine within the South African society, and how those principles ought to be applied. So in a sense, I firmly believe competition law and data privacy legislation links beautifully, partly because that's all I do in life and I love what I do. But if we look at the principles coming and being applied from a competition law antitrust perspective, all these issues, in fact, dovetail very nicely. And I think time will tell how we apply the data privacy legislation in terms of whether we want an extraterritorial application. And it's my personal view, I don't think that is appropriate, and I think there are other ways to consider and deal with these issues.
Thank you very much, Amor. That once again, thank you for the manner in which you've answered those questions. As I said, always very insightful, always very interesting to listen to your perspective. Thank you for that contribution. I would now like to hand over to my other colleague. I like calling him my colleague because we're both attorneys. Yes, in fact, Mr. Moorburger-Schmidt is also one of my colleagues. She's also an attorney. Mr. Lucian Pierce is from PPM Attorneys, and he has been in the ICT regulatory space, cyber law space for literally the last 20 years. He was admitted as an attorney of the High Court. Then he did a stint in London where he practiced for a prominent law firm there, where he really got to learn a lot about telecoms. And on his return back to our African soil, he then formed PPM Attorneys, which is one of the ICT law firms that can be reckoned with in the space. I personally know that he has a lot of areas of speciality and interest, such as e-commerce, cybersecurity, cyber criminality, and so forth. But for today, the topic, as we know, is data protection. So Lucian, without stealing your thunder and taking away from your time, I'd like to give over to you. And just a brief comment to the audience. We may be running slightly over 10 to 15 minutes. Please stick around so that when we are done with Mr. Pierce, we can ask one or two questions to the panel before we conclude the session. Over to you, Mr. Pierce. I think your mic is not on, Lucian.
I wonder if anyone's trademarked that term yet for 2020 and 2021. You're on mute. Thanks for pointing that out, Sizwe. It's great to be speaking to yourself and with all my colleagues who've been in this sector for ages. It's also great to be speaking to all those who've taken the time to log on and come and listen to what we have to say this morning. This is really something, as Amor pointed out, something that's quite emotive. It's created a lot of problems for many organizations. And I'm going to be speaking to you today from a very practical perspective. Over the past 7 or 10 days, I've had a number of clients call in and say, well, Lucian, what are the implications of this for our business? What do we do? Are we suddenly going to be giving away our data? Is WhatsApp and Facebook going to know that our directors are talking to each other because somehow they're going to know that this director is here and the other director is there across the globe? So there were lots of serious concerns that arose out of this from an organization perspective. So I know that many of the issues and the debate that happened over the past few days related to individuals and how WhatsApp would impact on them. But I'd like to take a slightly different approach. My colleagues are more I've just gone blank. Anyway, the other esteemed advocate spoke really well from an academic perspective about what the implications are. But I'm going to talk from a very practical perspective. And in this regard, I'm going to speak about me just change the slide. About 3 areas, or 2 areas very briefly. WhatsApp, and are there serious concerns for organizations? And then I'm going to touch on what organizations' options are. Ban WhatsApp or instant messaging, adapt, or implement technological measures. So the reason I've highlighted these 2 areas is because this is precisely what came up during the course of the 10 days from a business perspective. And clients needed answers for these issues. Should we be concerned? What should we do if there are indeed concerns? What are our options? If not WhatsApp, then who else can we use, or what else can we use? Is Signal an option? Is Telegram an option? And are there weaknesses in those systems as well? So a lot of time was spent debating this with legal advisors and technical people. And the reality, as Moore pointed out, is that there was a lot of hype. There was a lot of misinterpretation. And a lot of the concerns, really, particularly from a business perspective, in my opinion, were overblown, overemphasized. Now, I don't want to downplay the importance of privacy and the fact that we need to be concerned about who is doing what with our privacy. But at the same time, there needs to be a practical consideration, because if you go and you look at Papaya, and you look right at the very beginning, it speaks about ensuring privacy, but at the same time, it talks about not limiting the free flow of information to the extent that it does economic harm. So there are balances that need to be struck in that regard. So as far as businesses are concerned, are there in fact concerns? So some of the concerns that came up related to whether WhatsApp and Facebook, particularly because of the relationship, is capable of monitoring what organizations are saying, what they're doing. Well, Amor has dealt with it in a fair amount of detail, but the long and the short of it is that as far as the messages are concerned that are being sent, whether it be between employees, whether it be between directors, or different people within an organization, and perhaps even B2C, businesses to their customers, the reality is that the messages that are crossing the ether, once they're sent from one device and land up on the other device, are encrypted and nobody can see it. So as far as that is concerned, businesses need to be assured that their information is secret, is encrypted. And as WhatsApp promises on its terms, it says, as much as those messages might stay momentarily on its servers, as soon as it's delivered to the other party, it's deleted permanently from its servers. And in any event, if it is sitting on the servers, it's in an encrypted format that neither WhatsApp or anybody else who might be accessing its systems can see. So from that perspective, we established that there aren't any concerns as far as confidentiality and accessing communications and documents is concerned. So that disposed of that concern, of course, for these organizations and businesses that we were assisting. The next concern was, of course, now that the pot had been stirred, if it's not WhatsApp or Facebook who is able to see our communications, well, what about other third parties? We've all heard that there've been compromises, and we've all heard about certain technology that can be used to access messages on WhatsApp. Well, the reality is that those instances have indeed occurred, but the long and the short of it is that it was not WhatsApp's fault. And I'm not here to defend WhatsApp or Facebook. If you go and look at my, or you send me an invite on Facebook, you will not get an acceptance. And secondly, I only have 2 friends on Facebook. One is my sister and the other is our marketing manager. And that's only because our firm needs access to Facebook for its marketing. So I'm not going to be in Facebook simply because I also have my own paranoias. But as far as these organizations are concerned, particularly WhatsApp, I have confidence in the technology. But back to the breaches that have occurred, we've heard about journalists in the Middle East having their WhatsApp messages accessed and prosecutions following as a result of that. Well, the reality is that those breaches and accessing of WhatsApp messages occurred through other malware, if I could call it that, other pieces of software that were placed on the phone, and where perhaps either through a lack of knowledge or trickery, the phone was then infected and was then taken control of. And of course, once someone has control of your phone, we know they can access various parts of it, whether it be your camera, whether it be your email, whether it be WhatsApp. So in those instances, again, the result of the discussion was, well, there might well be breaches, and those breaches might well result in WhatsApp being accessed and problems arising. But in that instance, it's purely because of some other way that hackers or any other people might have accessed the phone. So that disposed of concerns regarding hacking and stealing of data, etc. It just comes down in that instance to making sure that the devices that are being used have appropriate security in place and that employees are trained on basic cybersecurity and what to look out for to ensure that their devices are not compromised. And the third aspect, of course, that arose was with regard to data ownership. So now you've got employees who are using WhatsApp to communicate. They might be sending sensitive documents, proposals, contacts, leads for sales. And in those instances, how do you protect that information? Well, of course, we've heard that the first way is to make sure that your devices are secure and that you've trained your employees appropriately. But what happens in instances where the employees themselves turn out to be bad apples, if I could call it that, where the employees are forwarding data, documents and other information on WhatsApp? What happens if the employees leave your organization and take their devices with them? Who owns that data, that business data? And what do you do about it? Do you simply ask the employee to delete it and rely on them? Do you have some sort of other mechanism that allows you to delete it? What happens if they refuse? Are you then going to compel them via some other mechanism, whether it be through courts or some other tribunal, to delete that information? So those are some of the concerns that came up as a result of all the hype around WhatsApp and this concern about monitoring and use of data. So we had to address that, and out of that came a number of recommendations or options. The first one, of course, is, as I mentioned to you, this global organization that we were advising. The knee-jerk reaction was simply to ban WhatsApp itself. And I think that's a bit unfair because there are many other instant messaging tools out there that could be used, not just the ones that have become popular in the past few days, being Telegram and Signal, but many others. And the idea was simply to ban WhatsApp itself and prohibit employees from using this. Of course, we can imagine that in an organization of 3,000 employees, let's say, who are spread across the world and who are suddenly told to stop using WhatsApp to communicate, the chaos that's going to arise out of that. How do you implement within a day or two a new instant messaging system that's going to allow everyone to communicate securely and reasonably confidently because of the fact that they know how to use WhatsApp already? But training people on these new systems is going to result in potentially bigger problems if mistakes are made. So from that perspective, is it practically possible to do that? Well, the main reason, of course, confidentiality and breaches. For me, there isn't a problem there. So if it's confidentiality that is a concern, then there's no need to move across to another instant messaging system or other alternative. Of course, the other reason is we've seen that there's a growing number of millennials who have gotten to communicate, whether it be on Teams, whether it be on WhatsApp, or one of the other instant messaging systems that are used. It's becoming more and more prevalent. And as these millennials become more senior in organizations, they're going to want to perpetuate the use of instant messaging. So do we go back to hiding in our caves and simply requiring people to communicate by email or some other method? I don't think so. I think that is a backward-looking approach. Of course, if there's no instant messaging, what are we going to use? Email? Well, email itself isn't that secure. We've seen compromises happening. So this whole thing of emotion had people thinking very irrationally, in my view, and it was likely to result in extreme and impractical steps. So the next option, of course, is for organizations to adapt. And by adapting, we mean take what you've got and make it fit in. So as far as WhatsApp is concerned, our suggestion was that this organization and the few others that came to us for advice formalize the way that WhatsApp is used, not in an overly long legalistic way, but in a practical way that makes employees understand what they are and are not allowed to do when using company data on WhatsApp. So, of course, what could these organizations do? Well, you've already got policies such as an email policy, such as a social media policy, and the idea behind that was simply to adapt these policies to incorporate and formalize the use of WhatsApp. And this would take care of what types of documents you're entitled to send via WhatsApp. And the idea was to have certain categorizations or types of information and documents that could be sent via WhatsApp. And in those circumstances, of course, training on how to ensure that it is sent to the correct people. And if something does go wrong, of course, what you could use to ensure that that is quickly resolved. Of course, the other aspect was in the policy. You could have considerations such as if you are going to be sending certain documents, then if they are within a particular category, the next step, of course, is to ensure that they are protected using technology. So perhaps encrypting them or having them password protected if they're at a certain level and sending them across. And of course, making sure that the password gets to that other person via a different channel. Because of course, we know it's very daft to send a password protected document on one medium and then send the password with the document or in the same medium. So of course, basic steps like that could ensure a certain amount of security. The next step, of course, was to actually look at the devices that employees are using and to make sure that those devices have sufficient protection in them to ensure that they're not compromised. We've seen the huge benefits, of course, to many organizations, we could call them states as well, nation states, of having economic espionage. There's the well-known case of the United States Steel Association, where certain steel companies had their systems compromised, their pricing positions were stolen, and it's alleged that the Chinese government then passed them on to Chinese steelmakers, who were then alleged to have positioned their prices in such a way that they had an advantage over US steelmakers in trade talks. So in those instances, we've got to make sure that devices are secure. And of course, in a policy like this, you've got to make sure that there are consequences and that employees and users know that if they don't comply, there is going to be some sort of penalty for them. It's not great to always have this big stick waving, and it's probably better to pitch it in a more carrot type of fashion to emphasize the benefits to the organization of using WhatsApp and ensuring security in this way. But that is absolutely one crucial element of a policy. So our advice was to adapt rather than simply throw WhatsApp out and similar instant messaging systems, but rather adapt and ensure that it is used within an acceptable way. The other aspect that we emphasized and touched on with the clients in their inquiries was to look at technological interventions to assist in the use of these instant messaging systems. And of course, one thing that was of a concern was where employees use their own devices for work related communications, the old BYOD, bring your own device approach. And some of the considerations there were to look at and make sure that organizations had made sufficient plans and put policies in place, and of course within contracts as well, to ensure that in certain instances and certain circumstances, the data that is held on a device, whether it be within WhatsApp or whether it be within an email application, is dealt with in a particular way when the employee leaves or if that device is lost. So that was highlighted as well. The other consideration was, of course, if the organization has the funds and the resources, then in that instance, it of course could adopt the approach of issuing devices, which many organizations do as well. And the last recommendation was to look at software solutions. Of course, we all know that when you join a system, there are ways to configure software like Office 365, if you've got an enterprise solution, to allow an administrator to delete certain portions of an employee's phone or device. So that is also one of the options that an organization could consider. There are of course other options as well, off-the-shelf software that could be implemented within an organization that again manages the use of instant messaging, such as WhatsApp. Of course, the best solution is, of course, to use something within a closed system. So perhaps Teams, make that the de facto communication mechanism for organizations. But of course, there are slight difficulties in terms of sending documents outside of the organization's system. So from that perspective, we gave guidance on how to deal with this. And just in summary, the whole aspect of concerns around confidentiality, again, as Amor says, and I don't want to sort of downplay the privacy aspect, but really there was a lot of misunderstanding that took place, particularly since the updates to the policy were focused on businesses. So in essence, when using WhatsApp, take these recommendations into account, is what we said to our clients. And of course, the reality is that there isn't going to be a sudden intrusion into your use of the app, and there isn't going to be a breach of confidentiality. So from a business perspective, this is how we advised our clients to proceed. And the reality is, if they didn't have these policies in place, then it is about time that they implement them anyway, just to ensure that their organization's information is protected. And as we know, POPIA protects juristic persons as well. So on that note, are there any questions?
Thank you, Mr. Pierce, for this. Yes, there are indeed questions for you. Let me just get to them. The first question is from Anonymous. Anonymous is asking, WhatsApp's encryption only extends to the relay of messages. It does not extend to the storage of messages on devices. Also, if businesses back up the conversations on Google Drive or iCloud, then whoever has access to the backups can access unencrypted messages. What are your thoughts? Over to you.
Yeah, so I think that the short answer is that a weakness of WhatsApp, or is it a weakness in the device that you are using, or the way that the organization handles that information? Which is why part of our advice to our clients when all of this came up was to look at the endpoints, at the devices themselves, and make sure that those are secure. Because as I said earlier on during the presentation, when people access WhatsApp and are able to hack in and steal information from WhatsApp messages, typically it's via an intrusion into the device itself, as opposed to getting into WhatsApp or somehow compromising the software. If I can draw an analogy, you are an attorney handling a very sensitive case. You make photocopies of certain documents in your very secure office. You put them into your locked briefcase. you drive home, you put them into your study, where I am, for example, leave the door open and somebody walks in and steals them. That's the analogy. Once the documents are on the device, it's not WhatsApp's fault if you are storing them in an unsecure manner. It is up to you to ensure that as soon as you receive that information, that the device or the location that you are storing it is secure. Very much like if I bring documents home and I put them on my desk, I should ensure that my windows and doors are locked so that somebody who's up to mischief can't access them.
Thank you very much for that answer. The next question comes from Phoenix. Phoenix is asking, how would the regulator approach the question of users migrating WhatsApp chat history to other platforms such as Telegram? Yeah, that is the question.
So how would the regulator address that? Well, I would think that you as the owner of your personal information are fully entitled to decide how you deal with that information. Very much like you could take certain personal information or photos of your kids, in my case, many of you might not have kids, and put them out there into the public domain. Similarly, if I have all my personal information within a particular app like WhatsApp, nothing stops me, just like the previous question raised, from taking that and transmitting it into or transferring it into a different communications app. So I can't see any issue in that, provided that where you're taking it to, if that new application, as long as that new application has decent privacy policies, I can't see any sort of regulator-related issues that arise out of that.
Thank you, Lucien. What also comes to mind is the whole data portability issue, which is addressed in the GDPR as well. Then the last question for you comes from Lucky. Why are we not given an option not to accept these terms and conditions?
Yeah, well, I suppose that goes to Francis. And Francis, I'm sorry, I had a blups earlier and your name popped out of my head. But that goes to sort of the issue that Francis raised, you know. Should you be given the option of different terms and refuse to accept but still use these applications? Well, you know, Francis did answer it to a certain extent, but I think, you know, the approach that these organizations take is a take it or leave it approach. This is how we operate. These are our terms and conditions. If we start tailoring these terms and conditions for every single country in the world, yes, I know there's an element of discrimination, as we've all seen, because the EU has its own terms and conditions. But the reality is that they're not going to tailor their terms and conditions for every single country in the world, because that would become a logistical nightmare. So I think they are taking the risk or taking the chance that you, because it's such a popular app, are simply going to accept and cave in. And again, it goes to whether this is real consent or not. But the reality is, because they hold such huge power and there's a huge bargaining imbalance, you're not really going to be able to force them to change those terms.
Thank you very much, Lucien, for those answers. And unfortunately, we've gotten to the end of the presentation. And as we know, with our new normal, there may be some of you who have other engagements. So time is key, and we need to respect time so that even the next time when we invite you, you do come and attend. But what I want to say before I go is that you know, it has really been an interesting 2 hours, and you won't believe how quick 2 hours goes. And some of the issues that have been raised here today are really issues that other people under normal circumstances may not want to ask in public. You know, that is why it is nice to have this type of academic debate and academic discourse within the perimeters of this webinar, where one can speak freely without any reprisals. So I just want to thank Mr. Pierce once again for his presentation, as well as Ms. Amorberger Schmidt for her presentation. and as well as Mr. Francis Cronier. Not to forget Advocate Colin Wieband, who graced us with his presence from the Information Regulator. And last but not least, I just want to thank everybody who attended the webinar today. And I'd like to thank the Dean of the Faculty of Law, as well as the Head of the Department of Mercantile Law for making this event possible, for seeing the importance of this event and the fact that we need to have this type of discourse. And as we do with our normal, we have a full production team that has assisted us today. The one is my colleague, Mr. Stephen Newman, who I'm sure you've been in contact with, as well as Dr. Hilma from the ICT department, as well as Ms. Roby. We thank you very much for the technical assistance that you've given us. And I would like to thank you from Pretoria. Thank you very much for attending this webinar. Goodbye and God bless.